Hi, I'm Chad McCoy.
And I'm Sheila Hiestand. We're with the law firm of McCoy and Sheila in both Louisville and Bardstown. We're here to talk to you today on our continuing series regarding the new medical review panels.
And what we want to talk about today on this segment is how these panels are going to impact your case and the entire process. And we've spent a lot of time actually talking with lawyers in other states that already have to deal with medical panels. And what we're finding is actually, from our standpoint, the process isn't going to change very much. We already like to get all of your medical records. We like to talk to your doctors. And most importantly, we like to get experts that are going to be able to independently evaluate your case and tell us whether or not there's been a breach of the standard of care. So all of that's not going to change, but unfortunately what is going to change is there's now going to be a huge delay before we can get to the end result. The way the law is designed, we're now not able to go to court until we either get an opinion from the panel or 9 months has passed. I don't think it's realistic that the panel is going to be done in 9 months, and I'm afraid what's going to happen is you're then going to have to file the lawsuit, and then the real problem is, I bet the judges are going to tell us, well, let's wait until we get the opinion from the panel. So now we've got this unknown delay. I can tell you that in Indiana, where they have it, the delay is almost 2.5, 3 years.
Yes. And unlike Indiana, everything that happens in the panel is admissible in the civil lawsuit. In Kentucky, the way they've written the law is that the judge will determine admissibility based upon the Kentucky Rules of Civil Procedure, the Kentucky Rules of Evidence as to what is admissible and what isn't admissible. So arguably the panel's decision could be admissible, but it's going to hinge on whether or not the judge decides to make it admissible. And that's another wrinkle in here. We have a lot more evidentiary issues that are going to have to be jumped over. So unfortunately, this is going to increase the length of time before our clients have access to a jury trial, which is unfortunate because the only group that benefits is the doctor or the corporation that we are suing, not the injured party.
And their insurance company. And where we think the biggest impact is going to be is, unfortunately, if it's for example, a failure to diagnose a cancer case. We're afraid our clients are going to pass away before we can actually get to a jury. In our next segment, we're going to look at how this has been handled in other states and what the impact has been.